individuals and entities likely to be required to comply with the rule, together with a general description of the types of individuals likely to be. Repealing the rule, could have an impact on the operations and maintenance assessment levied on the estimated 5,795 single family homes. That's a combination of about if you're keeping score. 1,880 multifamily homes and 207 commercial operations that are within the district boundaries. The average person per household is 2.36 in the area. That changes census. So an estimated effective population is almost 15,000 people when you add up all those homes. And assuming they need 1% occupancy, according to the rest. A good faith estimate of the cost of the agency and any other state local government entity, which is outside of the district, of course. Repeal of the rule will cost the agency an estimated could be $50,000. I don't know if it's going to be that, but in staff time and consultant fees to administer, because people can repeal the rule, even if you don't repeal the rule, you're going to have to revisit the methodology. It's time it really needs to be done every year. It's time to do the in-depth look at the methodology itself. So that's why I put in that amount of money. There will be no effect on the state or local revenues.
There's a gas Wi-Fi. She doesn't need one.
Here. And the other one is, good faith estimate of the transactional costs likely to be incurred by individuals and entities, including local government entities. Requires people to comply with the requirements of the rule. And the repeal of the rule will not require any transaction costs to any individuals or entities, including local government entities. Section E says an analysis of the impact on small businesses is defined in this state section, section 38 of statutes, and analysis of the impact on small farms and small farms. So we want to have a significant and small.
Nine.
And we put forward. Any additional information that we can forward. Additional information to be found. In the statement or the statement, whichever provides a description of regulatory alternatives submitted for the Texas one plan. And a statement adopting an alternative or a statement of the reasons for rejecting the alternative in favor of the proposed rule. No written proposal statement. Adopting an alternative or statement of the reasons for rejecting an alternative submitted. So based on that information provided during this statement of estimated regulatory costs, support the repealing of chapter 6 of the Gateway Services District Rules of Procedure. So according to this, the way we had to chase down or look at all the elements.
It's on the Wi-Fi.
And I have to be really adverse to that. So that
It's been advanced. I didn't find it. My computer was not cooperating.
Fix that, Mike.
And I'm going to do people who find out as representatives on behalf of the group voters, and then it is will be examining people and I can request to speak for the votes on behalf of an organization and 5 individuals. So please sure you can say your name and the organization representing yourself. The time for your people to come to there, you just get 5 minutes and eventually wait 3. First of all, I have so much university and behalf of the public and your community institution.
I want to thank the people from the Gateway. Gave support, call it reserve with the red shirts. What do you think about it? I'm Tom Chamber, Vice President of the Public Reserve Community Association. I begin by saying that I fully understand that this board has the authority to change any rule at any time. Nevertheless, in my opinion, it may be a fool's errand which you are embarked on in terms of repealing Rule 6. For 20 years, Rule 6 has proven to be a fair and equitable assessment methodology to recognize benefits received by each property owner in the Gateway CBD. The position that you would repeal the rule without having clear understanding and facts as to the ramifications of that action demonstrates a predetermined bias to the outcome. To those of you who are here tonight who are not from public preserver, are you clear on exactly what the repeal of Rule 6 would mean to you? As an example, it said that Gateway residents other than those from Pelican Preserve have incurred Gateway-related costs of $10 million over the last 5 years, for which the residents of Pelican Preserve have not contributed a penny. This may be true, but do you realize that in the same time period, Pelican Preserve residents spent $12 million on Gateway access within their community? So will changing Rule 6 result in Pelican paying $3 million of the $10 million? While non-Pelican Preserve Gateway residents might pay $8 million to maintain Gateway access at Pelican Preserve? Maybe you want to be sure before you advocate for the repeal of the rule. The point is that the repeal of Rule 6 is being proposed without any analysis on the impact of everyone. Having observed, however, the board's workshop and meeting on September 5th, which absolutely confirmed that the original adoption of Rule 6 was legal and remains so today, it was repeatedly uttered when we repealed the rule on September 19th. These words were said before the board's independent counsel opined that the original adoption might have been better qualified for the Florida statute 170 as opposed to 190. That seems slander below reasonable thinking, so that the public hearing now seems to be nothing more than a necessity required by Florida statute. From all evidence, it sadly seems that it is the foregone conclusion that the board will repeal Rule 6 and can still hold on. Thus, it seems apparent that the board will walk down the road to which the road is going. The board did say, however, in September workshop, it come in March when it will use Chapter 170 to develop a new assessment methodology. Why? You also learned on September 5th that the methodology used in 2022 to allocate the new bond did in fact follow that chapter. Now, continue to again. Whatever you do, should you repeal Rule 6, the new methodology must produce a fair and equitable outcome. Any attempt to establish any system that is not wholly fair, equitable, and based on benefits truly received by the residents of Gateway could easily lead to unnecessary litigation. Unfortunately, the actions you have taken relative to the repeal of Rule 6 are viewed by many as a subject of money grab. Uninformed Gateway residents here tonight will advocate for Pelican to pay its fair share. They don't seem to realize that Pelican Preserve residents already paid more in their non-ad-valorem assessment tax to Gateway than to any of them. Pelican residents pay on average over $1,200 each to Gateway. That is in addition to also paying city and county taxes, as well as to the more than $6,000 they pay to maintain their own community, plus the fees they pay to maintain their respective neighborhoods, of which there are 32. Yes, Pelican Preserve is not one neighborhood. It is a 55-plus age-restricted development composed of 32 separate and distinct neighborhoods, the same as Stony Brook or Gateway Greens. Taxing Pelican Preserve residents without providing them benefits is immoral and fundamentally wrong. On behalf of the 2,498 homes in Pelican Preserve, I hope you will reconsider your initiative to repeal Rule 6 and that you will vote down the motion. Thank you.
Okay, our next speaker is Carol Brockey, speaking on behalf of the Pelican Preserve Residents Alliance. Just so that you can be ready for who's coming next, I have Joel McCullough on behalf of Stony Brook.
name is Carol Ryan. I live at 105 listed right now. I am the president of the Residents Alliance. Why are we all here today? What do all the residents want? Both Gateway residents and Pelican residents want to be treated fairly. There are always two sides to it. Plus there are facts and there are emotions. Let's look at the facts concerning who pays and who doesn't pay for assets in the CBD. Number one, case law states all assessments have to be fair. We want them to be fair, equitable, and proportional. Florida statute 190.011 and 0.012 states the amount of the assessment shall be determined by the board based on the report of the district engineer and assessed by the board upon lands which may be part or all of the lands within the district benefited by the improvement. If Rule 6 gets repealed, there will be a district engineer report or a new assessment methodology. Let's take a look at the difference between general benefits and special benefits as defined in the Master Assessment Methodology Gateway Report 91/2022. A general benefit to the public at large is incidental in nature and are readily distinguishable from special and peculiar benefits. Flow is a logical connection from the applicable system, facility, and system. An example of a general benefit is me driving to church. I Gateway Boulevard, no charge. The two requirements for a valid assessment methodology are one. First, the property is assessed must receive a special and peculiar benefit as a logical connection for the system and service constituting the improvements. The courts recognize the special benefits which flow as a logical connection peculiar to the property as enhanced enjoyment, increased use of the property, which in turn may result in this decrease in insurance premium. Probably not going to help them now. Increased value and marketability. The second requirement, the assessment of fairly and reasonably apportioned in relationship of the benefit received by various properties being assessed. So think of a Gateway resident living in a condo can go to the Gateway Park and swim, easy access, a positive feature for selling that condo marketability. Not so for a public reserve resident going to the Gateway pool. The assessment methodology takes into consideration fifth generation breaks. How many diligence by a single family, a home, a supermarket, a general office, the more trips, the more benefits from roadway, landscaping, signage, lighting, and what you pay. They even check the stormwater runoff percentage. Many factors determine who pays what or who doesn't. There are some facts that you mentioned. Well, 6 is legal, and always been legal. There's been no changes since 2005. Even Florida statute 190 instead of 170 does not make it illegal. 3 attorneys have said so. Rule 6 is legal. So what does Pelican residents pay and what do Gateway residents pay? The 2,498 Pelican Reserve units pay 1,127 to 1,263 for the 2025 CBD budget. The 5,017 Gateway units pay $701 to 905 for 2025. I know what you will have. If Rule 6 is replaced, it will take 4 months to complete the engineering study and assessment methodology. Probably around January and February, which will tell us all of who pays and who pays and who doesn't.
That's good if you let her go.
The bottom line is speaking for the fiduciary duty to protect all every CDD member. The board needs to know for certain what residents will pay before they vote for districts. I have a petition I'd like to present to you. Okay, that we have 640 Portland residents who are north and did not have the opportunity to attend that. Wow. Yeah, but they're gonna tell you.
No.
Thank you. Thank you for your time.
Yes, you do. Okay, next we have Joe McCulca on deck. After that is Francis Iannucci from Daniels Preserve.
I'm Joseph McCullough from Stony Brook. I've this October with country about energy cellular. And for those that aren't aware, some of the thought that went in on this whole came back. Gateway didn't go through. It's only a few are Americans. It did not go through 82. Now that didn't happen. Before the rule was passed, the discussion was the different one than getting the question. The difference was that it does right on gateways, and there actually was a plan for the road to the bank of Pelican Reserve. There was the road with the current traffic sign for the neighborhood, but that was taken out. Instead, later on, they moved to another site that had for emergency accident. But I do want to address something. Over the years, I have 11 years precisely, I chaired the Stony Brook Advisory Committee. And I am very familiar with the budgets. And something that was not discussed was how much we pay. Stony Brook pays the same amount as everybody else in Gateway pays, other than Pelican. But the difference is that money goes directly to Gateway. The vast majority of it runs up in the local one fund, which operates and pays for the capital improvements in Gateway. The money that is paid by Pelican Preserve for the most part it actually goes into an OO2 account now. It used to be an OO3 paid bonds. No other community gets paid bonds from that, so that distorts that number a bit. In addition to the money that's paid into the OO4, it's added on to the number that you just mentioned. I think 700 some odd dollars. I can't remember if it's off the top of my head right now because I don't chair the committee anymore. But the fact is, we pay a lot more. It would have been way more than 700. We have been working to cut down the amount that is taken the OO4. I'm not sure what the final budget is for this year. It's probably $300,000 or $400,000. But I'm going to tell you this: over the years since 2011, when I first joined and became the chairman of that committee, we have paid about $5 or $6 million ourselves, in addition to the money that goes into the OO1 fund to pay for gateway assets that are in Stony Brook. But that's not what I really don't want to play for Stony Brook versus Pelican game. I want to make everyone aware that most of the money that goes into gateway from Pelican goes back right into the OO2 account and gets spent in Pelican. What has brought this to a head are the future plans to build a new office building and a park. Those two items are probably underestimated what their costs are going to be. I know the cost of building that new office building is way higher than it was. And that, in fact, it's come back with estimates for maintenance, operations, or insurance on that building that I personally am familiar with. Let me just say that really what got this community gateway up in arms is when they heard that two of the members from Pelican voted for it, knowing fully well they will not pay for it. Most of us do not benefit from these things. The partner won't benefit from. Stony Brook is an exception, has its own amenities that duplicate many of the amenities that have a golf course that duplicate many of the amenities that are in Pelican. We don't want this stuff. I'll be honest with you, we really don't want to spend the money. And the fact is, the park may happen, they don't know. But if you're going to vote for it, damn it, pay for it. I don't think that's fair. It really doesn't. I can't agree with anybody present like that. There are numbers I don't have in my fingertips. JT is here, he's the president right now, Stoneberg. And some of it has to do with the issue. I'm gonna turn it over to someone, if he can sit up here and talk later, it'd be great, because he can talk some numbers that I can't get to. And Ed, I know you and I have talked, and you have some things you can add to it, and I actually wish somebody had gotten up and talked, to present some of the issues that we have talked about, just not just me. But in any case, we do not want to work against Pelicans. We see them as potential allies and working and trying to make it look a better place. But all we're asking them to do is to be fair. That's all. Thank you.
All right, next up, we have Francis Iannucci. And after that will be Phil Rovner. And Phil, once you get up, your time will be reduced to the 3 minutes. And if you could please hold your applause till we're all done with all of the public comments, it'll make everything go a lot smoother. Thank you.
Well, maybe everyone, I'm Francis Iannucci. My approach is to be a lot simpler than what you heard before me. So here, we can use connectivity.
He gets 5 minutes on behalf of the community.
It's 3 areas in our district. The exemption from being said, and only incentives associated with roads, street signs, lights, sidewalks, monuments, landscaping, and all park and recreational expenses, provided in the street area is not directly connected to the or the drive. Now, 20 years ago, maybe there was a reason for this. I don't think there is anymore. I certainly think it should be repealed. Now, just from Daniels Preserve perspective, so I access Daniels Preserve from Daniels Parkway onto Commerce Lakes Road. Commerce Lakes Road is a private road. So I never drive on any gateway roads to get to my community. All the roads in my community are private roads. We pay for our roads, we pay for our lights, we pay for our amenities. So does that mean we should be exempt? No. I've never used Google, never used the golf park, never used soccer fields. But all of those things contribute to the gateway community. So when people come to buy my house, they're going to see all those things. Just like if they come to buy a house in Pelican Preserve. They're going to see those things, and they're going to benefit from those things. So I really don't understand the very nature of this house. We're saying, well, you are like we, but we're really not. And I just, I think we'll reach, whatever takes place, and they're going to do negotiations and studies to see what applies in today's world, not from 20 years ago. The rules should continue to exist just because it has. It doesn't make any sense. Other than that, I mean, I guess Pelican Preserve could succeed, become their own CDP. I wouldn't want to see that. I know some people from Pelican Preserve. I think they're great people. I think it's a great community. But I think we all need to come together for this. And we can't do that if we have a rule that allows Pelican Preserve residents to serve on the board and it says taxes that they don't have to pay. And again, I've been to a lot of meetings. These people are great authority on almost every subject that comes up. I don't know Karen that well, but the fact that she's serving and stood up says that she wants to help. So I think that somewhere in here, we can meet in the middle. That's got to start with a review of this rule.
Okay, next up we have Phil Rovner, and then on deck is Nancy Smith. Give me a second to get my timer reset, please.
Danny Rovner, living in 1155. For a question of the board, rationale for doing this replication after more than 19 years. Absolutely, communication with the staff and theology is previously. Rule 6 was initially
all in business connectivity agreement. Negotiated in good faith by both sides. The development was totally ignored and system gateway. Acknowledging the demographic differences between the two principal areas of the district. The underlying theory that the two communities did not have direct access to the other community without further having to traverse other roadways that were not within the perimeter of the district. In addition, a flood qualification development deserves an 80-55 plus community. Quite clearly differentiates the need and history of the underlying differences between other communities. And especially conventions were local six. Board has provided little or no reason or rationale for considering this revocation. Nothing has occurred or changed other than the supervisor's contention that Rule 6 was improperly drafted, in which today we agree that's not being the case. Board statute 135, grants 3, Title 13, which addresses the development district, provides guidelines related to the allocation of expenses, which shall be done on an equitable basis among various classes within the district. My position that the residential owners, Pelican Preserve and Gateway are indeed the same classes that was envisioned in the 2005 Rule 6 adopted by the board and now having survived without training for more than 19 years. I have accepted definition equitable distribution position rather than treating each party as equal. Equitable distribution holds that some factors make the ownership of property inherently unequal. In short, the district may revoke Rule 6, but it is obliged to employ the statute to allocate expenses equitably. Thank you very much.
Okay, next up, Nancy Smith, and then on deck, we have Diane Hanley.
I've been involved in over for 4 years. I'm very familiar with the income city agreements. I have direct understanding, trying to understand why the Republican proper due diligence is made in our boards, depending on this before any decision on whether Bill 6 should be amended or gone. I don't use any services myself. I'm a resident of a gateway. A Pelican Preserve provides me with everything I need. I did hear a gentleman just say that he feels like he's in the same situation. I can't speak to that other than a good shape document was signed by parties 2004, 2005, addressing Pelican Preserve, which is a 55 plus community. Again, just dumbfounded as to how we can even have this conversation today without data being provided to all residents of the gateway, so they know what the true facts are. And thank you for your time.
Next up is Diane Hanley, and then Rod Senior is on deck.
I have prepared something to say, but I'm not really concerned about. I'm beginning to realize, and also listening to what she was saying.
Can you please, ma'am, can you please state your name for the record?
Oh, I'm Diane Hanley, Wisconsin. And I'm also listening to what everybody else is saying, and I agree with the Supreme person of the town leader. I don't see how you can make a decision when it seems like you're acting on no facts. It's either applicable or don't applicable. We need to be given more opportunities to understand how you can make this more applicable. How you're going to pay for your bond for a big building and a big park that we at Pelican Preserve don't use. People in Stony Brook don't use, and probably 50 other subdivisions don't even use. Okay. Now, I realize that we all pay for things that we don't use. We don't all go to school, that we pay for the school. So somehow you have to make this be the benefits of all of us to make us want to pay because it is fair. Right now. It's divisive. It's argumentation. It's people against people. That are all neighbors. And I honestly think that we all need a lot more information, a lot more understanding of where the money is actually going. Not just 001 and 002. That doesn't make any sense. We need to understand. So that's what I'm asking. I'm asking as a resident of the whole area. We need more. We need you to be more visible, more, giving us more explanation of where all the money is going. Bonds, not bonds. We need to understand. If you all can explain, maybe people would want to pay. Right now,
And next up is again senior, and then our final speaker from the audience will be Tom Murphy.
The crossing the gateway agreements. Capital improvements are assessed based on the benefit flowing to the property as benefit special assessments. Annual O&M costs should be assessed to each one equally as maintenance special assessments and are not benefit based. However, Chapter 6 of the 5 exempts Pelican Reserve from paying towards O&M costs for parks and rec, landscaping and roadways. These costs have totaled $50 million over the last 19 years. Since Gateway comprises 2/3 of this total $7,700, Gateway should have paid $10 million and Pelican $5 million to cover these costs. But Chapter 6 has placed the entire cost burden of $15 million on Gateway and has exempted Pelican. Tonight is not a vendetta against my neighbours in Pelican Reserve. I understand your desire to maintain the status quo, but we all enjoy the benefits from living in one district and should share annual O&M costs, which are not benefit based. I hear Pelican Reserve's arguments for exemption based on being 55 plus, duplication of amenities, lack of connectivity. But please recognise, for example, that Gateway Greens also has a ton of 55 plus residents. Stony Brook has recreational amenities. Daniels Reserve also lacks connectivity, and its residents have a long drive to become a spa. Therefore, these arguments for Pelican's exemption do not stand, while the rest of Gateway pays. District ownership of facilities inside Pelican and Stony Brook is an aberration, and is a consequence of lawyers lacking foresight and common sense when they set up the district. This mess must be disentangled. Pelican's Gateway should enjoy ownership and control of its own facility, just as Gateway's 50 HOAs enjoy theirs. Chapter 6 was wrongly adopted in 2005. The district's attorney opined in the April 5th, 2007 minutes that all homeowners in the district should be assessed equally. This conflicts with Chapter 6, which specifically adopted in 2005, which exempts Pelican. Furthermore, an independent attorney opined that the wrong statutes and methodology were used in adopting Chapter 1605. In her report, the attorney carefully avoided legally exposing the district for past mistakes, but instead preferred to focus on how it should move forward. Florida Statute 190.021 subsections 2 and 3 clearly set out the provisions for special assessments. It amazes me how attorneys have been allowed to complicate a very simple exercise, unfortunately pitching our communities against each other in the process. Chapter 6.
Thank you, Rod. Thank you, Rod. Your time is up. Tom Murphy, you're up next.
I'd like to say that I think that everything Brad said, And some of the people from health people there, I don't, and Joe said, I'm not their enemy. You know, we are all trying to, get through this, this mess of this real stuff. And part of what led up to it is, it's Parks and Recs, proposal, which is gonna cost $7 million. I think that, we have two members of the supervisory board or members of, held in reserve, and they seem to vote yes for all of those things. I'm a senior citizen. I don't want to have to pay for things that I don't use. And I don't think that, you know, they're taking into consideration, that there is quite a large senior population in other communities throughout. And we're not going to use those facilities. They put out a survey and the survey came back. And it was in favor of not having the parks and spending money in it. It seemed that they plan on going ahead with it. That's kind of disturbing. If you ask the people whether they want it or not, and they continue to proceed with it, you're basically stopping us from face. I am in favor of repealing Rule 6. I think that, you know, however, still gateway was developed years ago, you know, everybody should participate in it, whether they get some direct benefit or not. There's a lot of things that I don't believe that other people have said, but I still pay my taxes. I know I have a little tax of about $1,400. I don't know where we got $7 to get from. And I'm just going to go up. And I hope that, you know, common sense prevails and we repeal this rule. Thank you very much.
All right, I'm just double checking that there's nobody online has their hand raised. You want to take this for Claudia? That's the last of public comment. No. No.
No.
She likes to be loud. No, no.
So I kind of want to take a step back and talk about how we got here, right? Because I'm listening to you guys, I could see there was confusion, and there was confusion among all of us, including boards and staff. We, as a board, decided to hire an outside attorney to take a look in depth into the adoption of the chapter 6. And, interpretation is available to all you guys to review on the website. The letter that was sent to the board and is written in So in summary, there were 3 key items that I wanted us to talk about. The first one was the adoption of the procedures. So this board had the ability to adopt rules, and we did. The issue is that her opinion is that we did not follow the correct procedures adopting that rule. The question is that rule valid? Yes, I understand the rule is valid because no judge has challenged or no one has challenged that rule, but if that comes to fruition, who would award and so on and so forth. So first it was, yes, we can do it. We didn't follow the correct procedures. One of the big questions that you guys wanted to know was why are we repealing the rule now and then find out the financial consequences later? There are 2 different things. So repealing the rule is going to start us with the process of engaging with engineers and the professionals to find out the new methodology that is going to be used to then come up with the financial information and data that will be between Gateway and Pelican. We do not know that data. We will know that data until January or March. We're going to have a first round by January, but completion of that information will be provided by us by the end of March. So we cannot answer you guys any questions regarding how is this going to financially impact you because we do not have that information. We will not have that information until January or March. But again, there is a second item. The first item is repealing or not repealing or amending the current rule that we have now to then follow the correct procedure that we needed and required to adopt a further rule in the future if that's what we choose to do so or not.
One other item regarding the benefit. Benefit will be established by the professionals. So they're going to be the one that will examine all the documents and they'll be providing that to the board. And that will take January and February. That will be engineers and the benefit, another item that we did not talk about. We heard a lot is, we're 55 and over community, we don't use those assets, we don't use that. The benefit is not necessarily to the person, the benefit is to the lot, the benefit is to the property. So if there, and a few of the examples that she gave on the September 5th meeting was, there's a value, an increase in value, so that is considered a benefit. If there's a storm issue, that it can be considered a benefit, a sidewalk, and in addition, it's a benefit to the lot. The benefit will always stay within the lot, not necessarily the owner of that. And again, I urge you guys to take the time, it's about an hour and 15 minutes. The video is posted on our website, and her letter of recommendation is also posted on our website. For you guys to take a look and truly listen to that we need to follow certain steps. We want to follow the right steps, which is, this is step one. And then come to the beginning of the year, once you have all the items in the reports, we know what the step two will be. And then at that time, more important than now, you guys need to show up. And then say, if we don't use this, how can we meet halfway? Your voice is going to be the most important between January and March. When we're having those workshops, when we're having those meetings, that the explanation is going to be given to us and to you guys. And that's when we guys ask the question, and that's what either meet halfway or make a decision one way or another. I think I kind of covered everything else. I will open to my vice chair and then we'll move to Carol, Bob, and then Doug. Thank you, guys.
Well, I want to thank everybody for coming out tonight. This is a very invested issue. A lot of people are taking this as personal. This is not personal. This is business. Mistakes were made 20 years ago. We can't correct those. We're not trying to correct those by going back and recovering, like Mr. Senior said, millions of dollars. But it's time for this thing to change.
I would be the action we probably would have shortly. However, I think everybody in this room has to agree that they have no idea what the effect of this going to be. Is the sun going to come up tomorrow? Absolutely yes. Are our lives going to change irrevocably because of this action tonight? Because of tomorrow? Absolutely not. But the work on the methodology and the work on how it is going to affect everybody, and if it is fair and exactly what the benefits are they specific? Are they general? Are they for all? Or do they apply to a particular property? And how much benefit there is to that property? All these questions are yet to be decided. I urge you very, very much to stay involved. Stay involved is to be active in your community and find out the answer that we can't give you tonight because nobody knows the answer. It hasn't been figured out. We need the answer before we make a decision. Moving forward, we have the answer to the question before we go throwing something out that's been for 20 years.
I have completely different vote, because in my house, we had the better ourselves, we got good buildings, so big, what we go to. order that wasn't followed. I don't know what to do. I really don't know how to do it. It could be a plus or something, and negative to the other. The bottom line is, this discussion should be taking place after we have the method. At the term, there was no disagreement on that process. I need to listen in the real world nature, if it was offered in July, voted on in November, the public meeting is in September, is absolutely perfect. So I said all I can say. I do vote, and I keep hearing that I need voting because I didn't vote for time. Let me assure you, I voted for the entire community elected. And I have not gotten gateway votes that never voted. And if I can, disrespectful things that I'm going to do a certain way. Do I live in Oregon? Absolutely. But I also understand what I also. And I don't think that those laws are considered gateway any more than the average homeowner person knows what this board does. So trust us, and hopefully we're going to get to a proper resolution in the future. What we're doing right now, I strongly disagree with that.
It's really good to see so many faces. I don't know if I was around every Thursday for me, but it's good to see everybody who's not. One thing I'll say is I've been on the board up here for 8 years. We've had multiple representatives from Pelican on this board. I think they've done an exceptional job representing Greenville as a whole, as well as Pelican. Both Bob and Carol and Bill and others, even before them, always look out for what's best, what's in the best interest of the gateway. So I'm all in that. So my position on this, originally when it came up, was to first determine if there was justification in your appeal. And that justification is based on should it have happened in the first place, or is there justification today to review? We've gotten some outside counsel, we've had internal discussions, which led us today, and I know that there's been some from Pelican who have asked the question, volunteer, it feels like a fast track. I think the reason why it might feel like that today is because based on council input, what was determined is the original process that was followed was not the proper process. But first and foremost, we need to make that decision on if it's not, if it wasn't the proper process in the past, let's follow the proper process. In order to do that, the chapter 6 has to be repealed. Now, if that's what the first day, and it's the first step to actually going down the proper process, which is looking at experts to determine the benefit. I think it's very difficult today to say exactly what that benefit is. So that's what step 2. Step 2 is bringing in experts to identify what's the benefit. And then alongside of that is determining how much benefit. And then the third piece of that is determining how much assessment would be adjustable. So we are following, what in my opinion, is following a proper process. We cannot determine today if there will be any impact to Pelican, yes or no, because we don't have the experts to weigh in on that. So we're following the process. The last thing I would say is, I think as a board, what we try to do is look at policies and procedures and make sure that everything we do is fair and equitable and what I was like to. And I think we're following that process today. The part of 170 that we will follow does require us to have benefit and also recommends benefit at the same time. We will have that in January. So to me, regardless of whether it's repeal or not repeal today, really where the rubber hits the road is doing our due diligence, having expert input in what is the benefit to Pelican, at what percentage, if any, and how it will be impacted or not impacted the assessment. But I appreciate everyone coming out and voicing their opinion, and we will be as transparent moving forward. I think everyone talk about transparency. This is transparent. And experts tell you provide their input, not by board members providing their opinions. So thank you very much. I appreciate your time.
I move to close the public hearing portion of this meeting.
I'll second that. Let's call for a vote. All in favor, say aye. Opposed? 5-0. I will ask you guys to just communicate or let's just, if you guys want to exit, I'll give 30 minutes and you guys can exit. Let me give them 3 minutes so we can exit. Or
Yeah.
Like that, sure.
I actually scared about this up here.
They do it all the time. Yeah. 2 ways to measure.
Yeah. Yeah.
if the meeting is still going, I just paused it. So what I'm saying is that's what they wanted us to do with the meeting still going. All right, we're good, so we're back to 10.
Regarding the repeal of a rule that is completed. Motion to repeal chapter 6.
Would you speak up louder, please? I can't hear you. Sure, another mic.
You slap, yes, Mike.
Thank you.
I'm sorry.
Much better.
Now the rules and the requirements of chapter 120.541 of the Florida statutes regarding the repeal of the rule have been satisfied. I now make the motion that we immediately repeal chapter 6 of the rules of Gateway. Application of the you include in that motion that the board adopt resolution 2024-27, adopting the rule that repeals chapter 6 as attached to the resolution. That's my motion.
Have a motion on the floor. Call for a second. I'll go ahead and second the motion. Any further discussion?
Yeah, from a discussion standpoint, so with this 7, does that also include the steps to proceed to follow the second or the second motion that will be demanded?
Yeah.
Just push up, wait a minute. You just gotta give it a second.
The action to be taken, set the public hearing is consideration of adopting a rule repealing chapter 6. The first step would be the board side, adopt resolution 124-27, adopting the rule repealing chapter 6 of the rules of the district. If the board wishes to discuss any other action, that was the notice we advertised for tonight's consideration, but the board could discuss the further steps after the board takes action. We'll be dealing with chapter 6.
Okay, so just to be clear, if we follow through with the vote. The support of that is, for me, the justification to appeal is to proceed with 170 on the proper procedures, which would include, engage expert engineering, having Russ continue with this methodology, understanding, yes. So if we can make that motion after the Ed's motion to ensure that we are, people are making understanding, so you're understanding that we're going to follow the proper procedure. Yes, in regard to the attorney's recommendations that was during the last meeting from back to okay. So if you report this, if we make a decision on this appeal to have a follow-up motion authorizing the procedure based on Maggie's recommendation to proceed with 170 and all the subsequent components of that.
Yes, what I would suggest, if after the action is taken and proposed repeal, or wishes to make any other motion, take any other action that's not on the agenda, then you then open up the floor again for comments on that particular action the board wants to take.
Just a reminder to the board that the last board meeting, you authorized district staff to move forward with Russ on the two different methodology processes, updating the current one and then totally doing an overhaul. So we are in that process right now.
Yes, Madam Chairman, I move to table this motion until the first meeting in March 2025.
Okay, so we have a motion to the table. We have a second by Bob. I'll go ahead and call it the roll. All in favor, say aye. Opposed, say no. No.
Right.
Carried, motion fails. So I'll go ahead and call for, so we had a motion by Vice Chair Single, and we had a second by Father Walsh for discussion. We'll go ahead and call.
This is sort of a discussion of operation. Am I correct in my thinking that nothing changes on the tax bill until sometime in March when we adopt, we're going to adopt the new?
The tax, the assessment roll for fiscal year 24-25 will be certified to the tax collector and property appraiser. And those are the numbers that will be going out in the tax bill issued by the tax collector. Next year, when the board adopts its budget, it should have the revised methodology, assessment methodology in place to make a determination as to what the level of assessment can be at that point in time for fiscal year 25-26.
But until a new methodology is developed, we maintain what we have. So if we don't know to look at the January, February, March, April, then we could well keep what we have through the 26th fiscal year. Is that correct?
The board has the current assessment methodology adopted in 2020, completely revised assessment methodology. That's what would be utilized if the board does not adopt another revised methodology before the adoption of the next budget and assessment roll. Is that how answer the question? But if the board takes the action to adopt this resolution, chapter 6 will not be in effect. That's correct.
I'll go ahead and call the motion to vote. All in favor of the motion, say aye. Aye. Oppose? Okay, motion passes 3-2.
And with all, I'd like to make a motion that the district staff needs to take action based on.
We have to open for public because it's not an agenda. So we're going to go ahead and open for public comments. If you would like to have any comment, you have 3 minutes to speak on it. that regarding,
We can go.
well, they have to speak before.
They don't know what we're.
Or can they just do it at the next meeting?
Okay, wait, do you want to explain what you're doing?
Well, what are we up to? Let's see the motion and then we'll. So my motion is to proceed with, that's, with the second slide, the meeting, regional one, with that, you do follow chapter 170, and it's recommended by Mooney for, opinion letter related to, property procedures, moving forward, was, the factors that. In that regard, if we follow all the recommendations outlined on that, we include, including the inheritance and and the other items.
It was 120 is for
Yeah,
some
it's like
groups for like skis and stuff.
And we'll make it open for public comment, we can just come to the voting.
Does anybody would like to speak? Rod? Anything? Identify yourself, please.
Senior Gateway Greens. I hear this motion and the first discussion 170. I've read every word of that section. It refers to capital improvements in R&M. And we're obviously going to be, we have an expert amongst this, Russ Warren. And I assume he's going to be, him or somebody of his character is going to be involved going forward with this assessment methodology. And I would not want to put him or any other consultant in a box, meaning following 170, because that is directed at municipalities, principally counties and cities and towns. The statute we need to be following is statute 190.021 subsection 2, which refers to capital improvement, which is a benefit central assessment, and 190.21 subsection 3, which is O&M, which is a maintenance assessment. And that's why I'm speaking right now, because I do not want this to be restricting us to 170 only. Thank you.
It's nothing I'm looking for. I'm hoping, because I keep hearing things like process and procedure to get an answer, so that I can understand why this motion wasn't done first prior to the motion that just passed. I don't understand why there's a process in place that says, oh, well, we can't do anything unless we get rid of this unnecessary thing. Trying to understand. That's what I'm question.
This advice that started with this push for parks and recreation. So it's a methodology that's not going to be available till January or maybe March. I will ask that you table any motions to go forward with the parks and recreation because this is provided to gateway.
Do we have anyone else who'd like to speak?
It's been brought at previous, CED meetings on the park survey. No one in Pelican Reserve received this park survey. You know, when we talk about, you know, they were going to go ahead and pay for it, it
Yeah.
would have been millions.
No.
And Pelican had even had a chance to answer their survey.
Yeah.
And then it's generation property owner health concern. I'm not retired. I'm a working registered nurse and it's on my properties. My property tax is up 118%.
I'm from New York originally, from Hunter County, thank you. But I'm here now and I will get involved because I don't want to go down this wonderful community that I've been part of for 20 years. My family's been here for a long time. What I'm asking you is when you mention the word transparency, it's everyone on this board willing to sign an affidavit that every expert that is brought in to do these studies, to do these evaluations, that nobody on this board or anyone connected with the development of this project and risk assessments and evaluation, be willing to sign an affidavit that you have no severe financial, familial benefit whatsoever to the parties that are hired doing these reassessments and evaluation and data gathering. Thank you. Great.
Anybody else?
Chapter 170. Look at chapter 190 with regard to the authority of the district to levy special assessment. It states that the authority of levy special assessment is construction, acquisition, and maintenance of the facility, authorizing the chapter using the receipt for levy and collection, finding in chapter 170 or chapter 197 for chapter. The process of 170, which utilized four of those sections, called 197 and 190. It's not going to be just the
That's correct.
So Ron, that's to your point. The motion that I made is for ending cover with respect.
We have a motion on the floor by Doug. Second by Bob. When I call for a vote, all in favor say aye. Aye. Opposed? 5-0.
Adjourn. Motion to adjourn.
in furtherance of what we just voted on. And in deference to Russ Weimer and everybody else who's been involved. I would like to have a third independent person or company or firm or whatever do exactly things that I did, so we get 2 reports. So we want to have somebody that's completely neutral, independent of any ties to this board or our current staff or our current assessment people.
Like the attorney opinion.
Yeah.
So what he said, Bob said, as we move forward in the process for engaging experts, that we should follow the same process we did for the attorney. You got a third party outside, either or. Yeah.
It's hard to be massive from that. Yeah.
We have to introduce we're going to use the difference. We are going to use our current district engineer, and that is one set of data. I'm suggesting and proposing, we have an independent, like we did on the list. Well, the money we're talking about now is Phoenix, but that's different. So I would just like that, we want to make sure everyone knows that it is fair, equitable, and totally independent.
No reason to believe that our consultants right now are not independent. I believe that they're totally independent. But I'm not sure that's.
So we have a position on the board. I'm going to call for a second.
No second.
We have a second by Doug. Anybody have any other comments? No, we have a motion by Bob and a second by Doug. We'll call this motion for a vote. All in favor say aye. Aye. Opposed? Aye. Motion passes 3-2.
I know the other things that they're very long.
I'm happy with that.
They're just saying some check your work.
It's pure, we adjourn.
Okay, so just to recap, the motion that was made is we will look for an additional assessment methodology expert professional. As a clarification. An engineer and an economist, that was.
I don't agree with assessment. That's just got like, where you're, what you're talking about the benefit. Correct. They have the interpretation of the, yeah, not the assessment. Correct.
So we need to hire a outside professional to determine the benefit.
Correct.
That's okay.
Two reports.
Okay.
That follows what we.
On the statute, people.
I guess for clarification is individuals such as economists, English economists, lawyer, and others, they perform and they do their assessment methodology report. They provided their opinion as to the benefits that accrue. And the Smith report also indicates what benefits accrue to property, the various infrastructure. Part of the economist's role, and Russ, correct me if I'm wrong, is to review the engineering report, make its own independent determination of what benefits the economist believes applies to each property and allocate the benefits to the property. The engineer does not provide any allocation of benefits. Is that correct?
That's correct.
Just for clarification. Need to have people provide public comment also to the crowd.
Any other public comment on that?
Let me just do the public comment on that. Yeah.
This is what we're going to do. On the last motion, I'd like to know.
They already voted on it.
For the additional costs, are going to come out of general fund or out of the telephone fund. Right. If it comes out of general fund, this is exactly why I'm doing tonight. If I didn't go into one thing to can happen. Only, the company, we pay the general fund, it's shown. I look at the budget all the time, I don't see it. That's one thing I always have.
Yeah.
Wait, anyone else would like to give public comment on that last motion?
Mr. Tinkle reference
You have to just slide it up.
is 190.021 subsection 2, 190.021 subsection 3. Both have similar language. It provides that the amount of assessment for the exercise of the district powers under 190.01 and 190.12 determined by the board based upon the report of the district's engineer and assessed by the board upon such lands. In subsection 3 about maintenance and special assessment also states that the amount of maintenance, special assessment for the exercise of the district's powers, etc., shall be determined by the board based upon the report of the district's engineer and assessed by the board. So if we keep lost, we have a district engineer. We do have a district engineer, so it could cause confusion. Is this the district's engineer? Small D, small E, or district engineer? So let's just go to problem at that point.
All right, so we have any other comments? No comments? Okay.
This is the housekeeping here from the parents.
Okay, go ahead.
Just for, before we adjourn, before you leave, make sure you loop around the parking lot. Please go on our district website and sign up for community notifications. It's under I want to subscribe to district notifications. And I appreciate everybody's time tonight and for coming out. And good night.
All right, we can also go to the second, no favor?